Let's talk about the impeachment process against Governor Fubara in Rivers State. Impeaching a governor in Nigeria involves a multi-step process outlined in Section 188 of the 1999 Constitution. It's not really a walk in the park. The first step begins with a written notice signed by at least 1/3 of the members of the State House of Assembly, which must be presented to the Speaker, alleging gross misconduct by the governor. This has already happened, I believe, yesterday in the case of Rivers State. This is then followed by the Speaker serving the governor and each member of the House of Assembly with a copy of the notice within 7 days. Step 3 is the reply to the allegations. Mr. Governor, according to the Constitution, has the right to reply to the allegation, and any statement made in reply must be served on each member of the House of Assembly. This step is followed by a resolution to investigate. So within 14 days, the House of Assembly must resolve by motion without debate whether to investigate the allegation, requiring a 2/3 majority. If the motion passes, the Chief Judge of the state must appoint a panel of 7 persons considered of unquestionable integrity to investigate the allegation, and that also must happen within 7 days. The panel must then report its findings to the House of Assembly within 3 months, and the governor has the right to defend himself. If the panel finds Mr. Governor guilty, the House of Assembly must consider the report, adopt it by a 2/3 majority within 14 days. Now, if that report is adopted, the governor shall be removed from office immediately. That's step 8. So it's a long process from step 1 to step 8. And the big question is whether or not all the conditions needed, will come easy for the Martin Amewule House of Assembly. Since 1999, about 6 governors have been impeached. 5 of the impeachments were later reversed by the court. Well, let's bring in Senior Advocate of Nigeria, Professor Roland Otaru, and legal practitioner G.T. Ogunye to better understand developments in Rivers. Gentlemen, thank you for joining us on the program this evening. Let's begin with Mr. Ogunye. There's a long list here of allegations in the lawmaker's notice, from refusal to present the budget, withdrawals from Consolidated Revenue Fund of Rivers State without an appropriation law. There are issues surrounding the appointment of persons without screening and confirmation, and also non-payment of allowance to lawmakers, among others. Do these allegations align with the provisions of Section 188? Let's begin from there, Mr. Ogunye.
Thank you for inviting me. Especially on the face of it, I have no hesitation in submitting that the allegations do align with the prescription, the constitutional prescription under Section 188. In any case, don't forget that Section 188 in its interpretation section liberally defines gross misconduct as meaning anything that the members of the House of Assembly, in their opinion, think is misconduct, or such a grave conduct that will be regarded as gross misconduct. So you're looking at the face of the allegations. They appear to have satisfied the constitutional prescription or definition of gross misconduct.
There's been some back and forth with correspondence between the governor and the lawmakers, especially as regards presenting the 2025 budget. Do you think the lawmakers were stalling, as claimed by the governor?
Whether
we'll get back to Mr. Ogunye while we work on that connection. Let's bring in Senior Advocate of Nigeria, Professor Roland Otaru. Professor Otaru, thanks for joining us on the program this evening. I want to hear your thoughts as regards what you make of developments in Rivers with the back and forth with correspondence between Mr. Governor and the lawmakers. saying that they have now kick-started the process of impeachment. Would you say they had been stalling all the while? Because we've seen 2 letters and 1 physical visit by Mr. Governor himself.
Hello, I didn't get that. The line was frozen for some moments.
All right. We lost connection with you, Mr. Ogunye, for a while. If you can hear me now, I'm asking.
I can hear you.
Yes, I'm asking if you think the lawmakers were stalling, you know, saying that they have now enacted an impeachment process against the governor.
Whether they were stalling or what?
Whether they were stalling not to have received the governor's presentation of the 2025 budget.
Okay, you know, let me just say generally, and I'll be specific. I think that following the Supreme Court's judgment, the parties, including the lawmakers, the parties to the dispute, need not play God. I honestly believe that both parties should have returned to the path charted earlier by the presidential intervention for the resolution of the conflict. That's my sincere opinion. What the lawmakers appear to be doing is that now that the Supreme Court has, by its decision, clarified the position, it appears that they are using their newfound legitimacy to revisit the wrongs, quote and unquote, that the governor had done. I think that that's not the path to peace, quite frankly. When the governor communicated with them, albeit the communication was in the public domain, perhaps again because the governor I feel that if he had just merely submitted a letter without publicizing the letter in the open, the assembly men, including the speaker, might feign ignorance of such communication. After that communication, physically, we saw that the governor went to the house and the premises were locked. I think that the members of the House of Assembly should have bent over backwards to accommodate the governor and then see how far they could, forge peace in that state. That's my sincere opinion.
Well, as of today, they still claim that they haven't received the letter. But what is the position of the law regarding the presentation of budget? Does the ongoing impeachment process gives the lawmakers the legal backing not to receive the governor?
No. Until the governor is impeached, he remains the governor. Until the governor is removed from office, he remains the governor. And therefore, the governor has a right to perform his constitutional duties, including presenting the budget that the Supreme Court had intervened should have been presented. Okay? And the members of the House of Assembly also have a constitutional obligation, if you ask me, to receive the governor if the governor indicates quite seriously that he wants to present the budget. I don't think that it's going to be the right step to take to say, oh, you've shot yourself in the foot. We're going to shut you out. We are going to disallow you from presenting the budget so that the allegations we are putting together will stick. If one of the allegations is that the governor has refused to present that budget, the member of the House may think that allowing the governor to present the budget, albeit belatedly, will water down that allegation or will knock off the bottom of that allegation. I don't think that legislative process, which is a constitutional exercise of power, should be a matter of chess game. I don't think so. Or be used essentially for political fault finding. I think that the governor must have learned some lessons. When all this crisis was going on, we kept insisting, contrary to what some interveners were saying, that it's ridiculous to suggest that 3 persons could constitute a legislature in the state. I don't know how you want to swing it or spun it, you know. And some people are saying, oh, there was a defection and whatever and all that. And my insistence is that the relevant provision of the Constitution says that it is the Speaker that will declare that seats are vacant.
Indeed.
It is the Speaker. Now, in this case, the Speaker himself had allegedly defected and thereafter swore to an affidavit to that effect. But he's still the one to declare a seat vacant. So if he's not doing that, the recourse is to go to court to seek an order of mandamus to compel him to declare himself, the seat of himself, and the others are vacant. That's the part of the rule of law. Rather than the executive, resorting to self-help and claiming that as far as the executive is concerned, at that time, the seats have been declared vacant. They are no longer members of the House. And there were a lot of people who are reasoning like that, and I found that very strange. Now, impeachment process, impeachment exercise, if I must say, is never an easy process. It's never an easy process. If you look at the precedent here, whether the Alamaisega precedent, the Dariye precedent, and the Ladoja precedent, which all went to the Supreme Court, it's never an easy process. Ladoja was reinstated, Dariye was reinstated.
I am hearing what they are saying. I have problem with service. I'm hearing what they are saying.
Okay, just a bit of challenge here, Mr. Ogunye. We're also trying to connect with Professor Roland Otaro, Senior Advocate of Nigeria. So let me confirm if you can hear me. Professor Otaro, are you there? Professor Otaro, you have to unmute yourself so we can hear you from here. All right. We probably will keep working on that connection. Mr. Ogunye, it's you and I for now. Let me interrupt your thought process to bring in the issue of Section 188 that requires, because like you have said, it is never an easy process to impeach a governor. In fact, about 5 out of the 6 impeachments we've seen since 1999 were reversed by the court. Even though in some cases, time had passed and it was just a mere academic exercise. But this section of the law requires that the chief judge appoint a panel of 7 persons to investigate the allegation within 7 days. Interestingly, the chief judge in this case is also being investigated by the lawmakers. How does that make this impeachment process peculiar?
Well, it is, that's the conundrum we're talking about. I've said generally that impeachment exercise in this climate or removal from office of a governor is never an easy exercise. It is easier if the political forces are aligned and are insistent on the removal of a public office holder from office. For example, in Lagos, it was easy for the then governor of Lagos State, Bola Ahmed Tinubu, to cause his deputy governors twice to be removed from office. Okay? But if the political forces are not that aligned and there is a huge controversy and crisis as we've had in Rivers State for some time now, it's usually very difficult politically to accomplish. Not to talk of the deliberately crafted provisions of the Constitution, which makes the process cumbersome. Now, to your question specifically, the chief judge of the state is facing some allegations from the legislators. Now, he is now required by the action the legislators have taken, to, after now, set up a panel of persons of using the constitutional language on questionable integrity, who are not members of any House of Assembly, who are not politicians, and who are not in the public service, into a panel of 7 to investigate the allegations. for 3 months. They may post haste investigate and in 1 week or in 2 weeks say that they've concluded, right? But they have 3 months constitutionally to make this investigation. The question is, where would the Chief Judge easily find such persons? In Rivers State, without any allegation of bias or of deliberately skewing the appointment in a way that the governor will come out fine or the governor will come out condemned. So it's a very tough exercise, even at best of times. Not when that same CJ that is expected to perform this constitutional duty is himself facing certain allegations from the same persons, the same members of the House of Assembly that have kick-started this process of removal from office.
Mr. Ogunye, just last night, an explosion rocked the Trans-Niger pipeline in Rivers. The cause is still unknown, but we've heard militants threaten violence if the governor is impeached. So do you think there are still rooms for a political solution? Mr. President today met with service chiefs. It's not clear why that meeting held. But is there a constitutional role for the federal government and the National Assembly to still play in this regard, given what appears an impending crisis? I remember speaking with the former Inspector General of Police, Michael Kiro, who mentioned that he also has intel that things could easily go south if they impeach Governor Fubara.
Okay, let me answer the question this way. And it's a very sensitive question. Constitutional duty must not be run away from just because there are fears that certain persons may cause violence. Once that happens, it means that those who are elected to discharge the functions of their office without fear or favor, affection or ill will can no longer do so because of fear of the unknown, the fear of those who may, use violence to overwhelm the system and dissuade the authorities, those who are constitutionally empowered to act in one way or the other, from acting. So generally, I believe that regardless of whether the heaven is going to fall down tomorrow or not, if it is meritorious, if the exercise is good for Rivers State, it should be embarked upon, But I must say that those who are saying now, I believe, that, oh, this is just the tip of the iceberg, violence is going to erupt in Rivers State, we've told you so, in self-justification of their forecast, shouldn't be celebrated. I hate the idea of a political process, a civil process, being taken over by violence. So there's a political crisis in Rivers State right now. Yeah. So oil pipelines are being blown up. So what's the connection? What's the nexus? So is Rivers State the owners of the oil pipelines? No. So what's the issue? I don't see the reason why we should celebrate violence just because we do not want, the political crisis to escalate.
I get your point, Mr. Ogunye.
However, finally,
yes.
And I'm in this point. When the president intervened the last time, and some of our colleagues and people were saying that the president had no such constitutional rule, I reason differently. So, if you ask me whether that political solution could still be found, without hesitation, I will tell you that it could still be found. Only recently, the president did something regarding Lagos State House of Assembly. Okay? So, regardless of the fact that Rivers State, the party in power is not the president party, the president should, and I'm making this open recommendation, return to that matter, call the parties and say, look, this is the path we've agreed on before. Why did you resile from that path? Why did you go back to Rivers State and say, we can't work with that? So it's still a workable path. Can we return to that? Governor, you are not going to be impeached. You'll be given some guarantees, but members of the House of Assembly right will be restored. They will perform their duties. They will screen commissioner afresh. They will receive, proposed budget so that they can consider it, and so on and so forth. And then that path will be there. And if anybody then wants to remove the governor, eventually, 2027 is not too far away. I think that's just the path to the resolution of the crisis.
A good place to leave it, Mr. Ogunye. You mentioned that removing Governor Fubara won't come easy, given the experiences we've had in the past. The question of how do they navigate the position of the chief judge, who appears to be loyal to the incumbent governor. We see how it all plays out, especially your suggestion of Mr. President's intervention once again. Legal practitioner J.T. Ogunye, it's always a pleasure having you on the program. Thank you for joining us.
Yeah, thank you so much.
That's our show today, everyone. You can watch it